you protect me from a bank levy, wage garnishment, or seizure of real property?
No.
You're probably watching this because your bank account just got frozen. Your paycheck's about to be garnished. Or you got a notice that someone's trying to force the sale of your property. And right now, you're wondering, can anyone actually stop this, or is it already too late? I'm John Sterbick. I'm a tax attorney here in Tacoma. And for years, I've helped Washington clients deal with IRS levies, wage garnishments, and property seizures, including cases where action had to happen fast. Here's the truth. In many situations, yes, we can stop a levy, release a garnishment, or prevent the seizure of real property, but only if you understand what tools are available and when to use them. In this video, I'm going to walk you through exactly how bank levies work, how wage garnishments can be challenged, and what options exist to protect your home and other assets. So you can move from panic and uncertainty to having a clear plan and avoid losing your income, your savings, or your property simply because you didn't act in time. Bank levies. Can the IRS take my money? A bank levy is when a creditor or the IRS takes money directly from your bank account to satisfy a debt. If it's a private creditor, they usually have to sue you first and obtain a judgment before they can levy your account. The IRS does not need to sue you. However, they must send a series of notices, including a final notice of intent to levy. Once that notice is issued, you generally have 30 days to act. If you contact me during that 30-day window, we can request what's called a collection due process hearing. That request legally pauses the levy while we challenge it or negotiate a resolution. Depending on your situation, we may be able to demonstrate financial hardship, set up a payment plan, submit an offer in compromise, request currently non-collectible status. If the levy has already happened, we can sometimes recover funds, especially if the money taken was legally exempt under Washington law. But it is always easier to act before your account is frozen or drained. Wage garnishment. How much can they take? In Washington, most private creditors cannot take more than 25% of your disposable earnings or the amount your wages exceed 35 times the federal minimum wage, whichever is less. The IRS uses a different formula and can sometimes take more, but they still must provide notice before garnishment begins. If you act quickly, we may be able to negotiate directly with the IRS, set an installment agreement, demonstrate financial hardship, challenge mistakes in the amount claimed. If garnishment has already started, filing for bankruptcy can stop it immediately through what's called the automatic stay. Once a bankruptcy case is filed, most collection activity, including wage garnishment, must stop. That immediate relief often gives clients the breathing room they need to stabilize their finances. Can they take my home? For many people, this is the biggest fear. In Washington, seizure of a primary residence is rare, but it happens, especially by the IRS. Before seizing real property, the IRS must issue multiple notices, provide appeal rights, and obtain a court approval. Private collectors face even more procedural steps before forcing the sale of the property. Washington law also provides a homestead exemption that protects up to $500,000 of equity in your primary residence. That protection can significantly limit a creditor's ability to force a sale. However rare, does not mean impossible. If notices are ignored and deadlines are missed, your options narrow quickly. Your clients come in early after receiving warning letters, but before a sale is scheduled, we can often negotiate installment agreements, demonstrate hardship, reconstruct debt through Chapter 13 bankruptcy, or otherwise stop the process before it escalates. Why timing matters. The law provides windows of opportunity. For IRS levies, you typically have 30 days from the final notice to request a hearing. For certain wage garnishments, you may have as little as 20 days to file an objection. Once court proceedings advance, deadlines move quickly. The earlier you act, the more legal tools are available to you. What bankruptcy can and cannot do. Bankruptcy is not right for everyone, and it does not eliminate every type of debt. Some recent taxes, child support, and student loans may still be collectible. However, when property filed in Washington, bankruptcy triggers the automatic stay. That court order immediately stops most levies, garnishments, foreclosures, and collection lawsuits. Chapter 7 can eliminate many unsecured debts relatively quickly. Chapter 13 allows you to keep property while restructuring payments over time. For many clients, bankruptcy provides immediate relief and a structured path forward. The most important thing to remember, if you are watching this before your bank account has been drained, before your wages have been significantly reduced, or before a foreclosure sale has been scheduled, you are in a stronger position than you think. The law provides protections, but they must be used correctly and on time. If you wait until after the damage is done, your options narrow. If you act early, we can often pause collection, protect exempt assets, and negotiate from a position of strength. You do not have to face this alone. If you're concerned specifically about your home, I encourage you to watch our next video where I explain whether the IRS can seize your house for unpaid taxes and exact steps they must follow here in Washington State. Understanding those steps could make all the difference. I'll see you in that next video.